referendum, then it must still be subjected to the people for a referendum to take place. So the question that we are left asking ourselves is, if Senate and National Assembly pass this amendment bill tomorrow, will the clauses that are not subject to a referendum become law immediately? It's still a gray area in law because we do not have a referendum bill yet. Essentially, interpreting the law literally as it were, those clauses that do not require a referendum should be deemed to be law immediately Senate and National Assembly pass them. And therefore, it would only leave us with the issues that are required to go into a referendum. Now, Article 255 of the Constitution lists the areas that would require a referendum. And this includes the supremacy of the Constitution, any amendment affecting the territory of Kenya, any amendment affecting the sovereignty of the people of Kenya, an amendment affecting Article 10, which talks about our national values. In fact, just Article 10.2, which talks about our national values and principles of governance. Any amendment touching on the Bill of Rights. Any amendment touching on the term of the office of the President. Any amendment touching on the independence of the judiciary and any of the independent offices or commissions. Any amendment touching on the functions of Parliament. Any amendment touching on the structure of the devolved governments, those would require a referendum. Okay. Now, looking at the document presented to us in November 25, the Constitutional Draft Amendment Bill, there's one amendment that touches on the Bill of Rights. That's the one that touches on privacy. There's one amendment that you could arguably say touches on the functions of government, and that's the one that expands the role of Senate and its oversight over the county governments. And there is also the debatable one around the independence of the judiciary. Does the introduction of the ombudsman affect the independence of the judiciary? And basically, those would be the three issues in the entire document that would require. So, dicey area in terms of will the rest of the document deem to have passed and only three issues will be brought past in a referendum? I don't know the answer to that yet. We will continue to have debates on that. So that is it for an introduction of what has happened so far, what we have. We all know now that the process is lying in Parliament, and post that we are all looking forward to a referendum. And that's where we agree. We all know where the BBI came from, the handshake, the story is well known to all Kenyans. And I don't know whether we know the 9 issues that the BBI set out to solve. Are we aware?
Yes.
Are we aware of the 9 issues?
Yes. Some of us.
Okay, the 9 issues, I'll quickly go over them. One was ethnic antagonism and competition. That was really hitting Kenya's so little. Kenya was, as years put it, a Ferrari nation. Run by 2 tribes, and therefore there was a lot of competition and ethnic antagonism. Then also they claim that we as Kenyans lack a national ethos. We don't have values, we don't love our country, we don't have feeling for Kenya and Africa in question. And there's the issue of inclusivity. How do we bring everyone to the table? How does everyone share in this thing that is developed in Kenya? Then devolution was also under threat and an issue that needed to be discussed further. Then our elections and how they divide the country was also an issue. Our elections divide us. In fact, some of us who see elections tunahama penye tunaishi. So that was also a big issue. Then general safety and security for Kenyans was also a big concern. And most of the issues around this was just that the police are a little overbearing and treat Kenyans in a very demeaning manner. And safety and security was picked as an issue. all know. And I think we know it so well, we are almost ignoring it. It's becoming cumbersome. And that is dangerous. We need not get so used to corruption that we ignore it. We need to continue to talk about it. Then there was the issue of shared prosperity. How do we share the revenue in Kenya equally? How do we share jobs? How do we share responsibility? Those are some of the things we talked about. And then there were responsibilities and rights. So when you look at the proposals in the Constitutional Amendment Bill, and if you read the steering committee report that was released in October last year, you will see that these issues are addressed either in policy reform, administrative reform, and a lot of them will come up in the Constitutional Amendment. So when you look at the proposed amendments to the Constitution, they are not solving all the 9 issues, because the steering committee also had policy proposals and administrative proposals. Then they also had statutory amendment proposals in that report. So this is just one limb of the work of the BBI. And I think we really need to have that at the back of our minds as we go forward. So quickly, I'll jump into the proposals of the draft amendment, Constitutional Amendment Bill. The first one is to Article 10. And this is not Article 10 to which we require referendum, it's just Article 10. And what is proposed is to introduce a new clause into Article 10 that embraces the goals of African unity and the East African community. So this is just to ensure that as a country, Kenya, we are not left behind in the region, and we embrace the regional policies and regional alignments that we have, and that this becomes a constitutional requirement and not just a policy decision made at government or administrative level. The next proposal is to amend Article 11, which deals with our culture. And in Article 11, we are trying to introduce the issue of shared prosperity. And this again is an issue, one of the 9 issues that EDI was supposed to address. And they are trying to do this by putting in proposals that promote industrialization and support small and micro enterprise organizations. And this is very good because it will therefore have initiate a process where laws are put in place to protect intellectual rights, to support industrialization, small businesses, dual-party sector. These are the things that can go if this is put in the Constitution. So I think it's a very good proposal. We have amendments proposed to Article 18. Article 18 deals with citizenship. And in dealing with citizenship, the BBI committee identified that Kenyans enjoy a lot of rights. We have one of the most progressive Bill of Rights in the Constitution of Kenya. But we have no responsibilities. And rights without responsibilities create a bad sphere. So they decided to report into the Constitution responsibilities of a citizen. And they outline various responsibilities that attach to the well-being of the family, that protect ethical conduct, that condemns corruption, that talks about the honesty around paying our taxes, respect for private property and promoting private property and actually public land as well, then avoiding wastage of public funds and promoting the unity and dignity of the African people. So again, there we're just trying to enhance our values as a people, and I think that's one area that the church can actually help the state in promoting a constitutional provision in those areas of responsibilities. Then there is Article 31 that deals with privacy. And privacy is under the Bill of Rights. So this is the one area I said might require referendum, because we are making an amendment to the Bill of Rights. And what is proposed here is a very, very tiny little amendment to protect our personal data. The right to protect personal data. Now, this is a good provision to a great extent, but can also be abused if you think around it. Because that means if I'm, for instance, being charged with a criminal corruption case, I can refuse to give data around my savings, for instance, around my banking, around my activities, and say that is personal data. So it might be, I hope the statute that builds onto this gives a leeway for the state to be able to infringe this right, to limit this right to such an extent so that it is not abused to protect criminal activities. Then we have the amendment to the famous Chapter 6, which is the chapter on leadership in the Constitution. And the proposal here is to pass legislation that will enable speedy investigations and prosecution of cases that touch on leadership, corruption, and other practices. So that's what's proposed there, and I think that is very, very well. Then we have proposals to Article 82, which provides that Parliament should, within 6 months of the passing of this amendment bill, develop a law or pass a law that will provide for punishment of political parties that do not submit party lists that are gender balanced, or party lists that meet the 2/3 gender requirement in the Constitution. And I think this is a useful provision in the law, but it will be up to us as a people to ensure that that law is also not abused, because what a political party can set out to do is to fill the weak agenda, let me call that weak agenda, it could be male, it could be female, to fill the weak agenda in areas where that political party has no no followers, so that, let's say this is Nyanza, so this ODM is strong here, definitely. So Jubilee would probably field their women in Kisumu, just so that their party list meets the 2/3 agenda. But they know they will not be elected, and that will not serve the purpose of this, because the purpose of this is to enable more of the weaker gender to get into Parliament. So it is up to us also to be vigilant and keep that in mind. Then there is the amendment proposed to Article 87, which deals with electoral disputes. Currently, the provision in the Constitution is that IEC can actually listen to election disputes arising from nominations. It is proposed that Parliament makes a law to guide how this is done, and that IEC no longer sits on election disputes. And I think that's just to enable IEC focus on elections in itself. Then we have Article 88, which is proposed to be amended to stop the president, the deputy president, a county governor, and a deputy county governor in the last 5 years from sitting as a commissioner of the IEBC. So that if I'm a serving governor, I cannot resign now and go and join IEBC as a commissioner and run the election. There must be a 5-year gap between your resignation and your joining IEBC as a commissioner. I think this is just to rule out conflict, because you'll still be having alliances behind you, so it's to rule out conflict. Currently, the law only excludes sitting members of Parliament from that, so they're expanding the bandwidth of who may not serve at IEBC at any time. Then there's Article 89, proposed amendments, which deals with the limitation of electoral units. And we all know we currently have 290 constituencies. It is proposed there to now amend that article to increase the number of constituencies from 290 to 360. If this passes, then we will increase the membership of the National Assembly, not Parliament. Parliament is National Assembly and Senate. Membership of the National Assembly only by at least 24%. The goal of this is to promote fair representation, because as we go forward, you will see that we are trying to also achieve gender balance in the new assembly, and also to ensure that constituencies are not too large population-wise, so that they do not get fair representation from a single member of Parliament, and that's the intention in the draft. The process of reviewing boundaries is actually a mandate of the IBC, but IBC actually delimits. What this is doing is creating. I do not know whether there's a difference, but I know every word is different. So this amendment is creating new constituencies. And then it is requiring IBC to go out and delimit those boundaries. So there may not be any usurping of the power of IBC, but then again, maybe just creating a precedent when in the future, new constituencies are created rather than delimited by the IBC. Then we have proposed changes to the parliament, which are found in Articles 90, 97, and 98 of the Constitution. The first one is what we just talked about, the increase of constituencies from 290 to 360. Then the other one is they do away with the women rep as we know them. So tunajua women rep. So we are doing away with women rep. There will be no more women reps in the National Assembly. The National Assembly will have 360 elected members, and then we shall nominate such number of special seat members to achieve the 2/3 gender balance. So to get women into parliament, they will not be elected now, they will be nominated as special seat members so that the 2/3 gender balance is achieved. This has been a thorny issue of how do we achieve 2/3 gender balance in National Assembly, and we have been unable to resolve because there was no provision in the Constitution for it. So now this is a provision to get nominations to achieve gender balance in the National Assembly. We have a similar provision existing currently in the county assemblies, and you will see that the county assemblies, all of them have the right gender balance, except National Assembly. So they're trying to resolve that. But they do that by taking away the 47 women elected seats, which I think is very unfortunate, but has to be done. The other thing that happens is they reduce the opportunities for nominating people that currently exist from 12 to 6. So currently there were 12 people to be nominated, right now we are only going to nominate 4 people with disabilities and 2 youth. So we are only going to nominate 6 directly, and then such number that will be needed to balance. So that's how it will look in the future. Then the National Assembly will also have a leader, an official leader of opposition sitting in there, and the GS explained about this quite well in the morning, why we need that official leader of opposition in the Assembly. Then it will also have cabinet ministers sitting in the National Assembly as ex-officio members. The Attorney General will sit in the Assembly as ex-officio members. The Deputy Prime Ministers, if any are elected from outside Parliament, will also sit there as ex-officio members. So we'll have a very expanded National Assembly going forward. Now, this provision for nominating such number of women to balance the gender will lapse after 3 elections. So it will not be forever. After 3 elections, it will lapse. So we'll only have, after 3 elections, which is 15 years from now, we will only have 360 members of the Assembly. We'll only have 12 nominated members and the ex-officio members. So after about 15 years, the numbers in the House will reduce from a number of about 500, which we are projecting now, to a number of about 390. So again, that's something we should have at the back of our minds, that the provision for nominating such number of special seat members is an affirmative action provision that will lapse up to 15 years, and after those 15 years, then the size of the Assembly will reduce to under 400. So that again is something we need to keep at the back of our minds as we read these provisions. Then when it comes to Senate, it is proposed to have each county having 2 senators. Each county having 2 senators, so that means we will have 94 senators in Senate. And In Senate, therefore, there is no provision for nominating anyone. No nominations at all in Senate because we have gender parity right from go at the election. The only worry there might be that how do we ensure people with disabilities and youth get representation in Senate? But generally, it will have gender parity, and therefore no nominations are provided for in Senate. Now, currently the nomination seats, each party gets a certain quota of seats for nomination in the National Assembly. And now it is based on the number of seats that a political party has won. The number of seats or MPs to Senate, the number of MPs a party has in the House is what is used to determine how many extra seats will be given as a party to nominate people. But the proposal in the amendment bill is that that nomination now will not be based on the number of MPs you got as a party, but it will be based on the overall number of votes that party got. So this will give opportunity for where you are probably number 2, umeshindwa na kura kidogo, and probably you don't have the MP, but you get a lot of votes, but you don't get the MP. It will give those other parties an opportunity to nominate. Because right now it's a winner takes it all. Kama we si number 1, nominate. But this will give an opportunity to those parties who are pengine number 2 everywhere. So kura zao in total, jumla are a lot, but they do not have the seats in parliament. So the proposal is to look at the overall influence of that party, so that the percentage of votes a party gets is what will be used to determine how many seats a party is allocated. I hope that is clear. Yeah. So generally, those are the proposed amendments to the National Assembly and Senate. The only thing is women lose the seats they already have. They are saying that's a clawback to the rights they had gained. But then again, there's the opportunity to be nominated, expose them to politics, and within 15 years they should be right to vie independently as candidates. So there is then the proposed amendment to Article 96, which I said is also could be deemed a referendum issue. This is the issue where the role of Senate is expanded. Currently, Senate only oversights money that is allocated to the counties from the national revenue. So it's only the money that comes from the national revenue that Senate can question county assemblies about. The proposal here is to ensure that Senate can question them also about hizi pesa wana collect hapa kwa town, because they collect a lot of revenue in the licensing and other issues, but they are not oversighted currently under the Constitution. So the proposal is to expand the function of Senate to not only oversight ile pesa inatoka treasury, lakini also the money that a county can collect on the ground. And I think that's a powerful provision, but it's a provision that requires a referendum if it is to see the light of the day. Then we have proposed amendments to Article 99, which deals with qualifications and disqualifications for election as a member of parliament. I don't know why. This is a very curious part of the Constitution. It provides that an MCA cannot vie to become an MP. It is there in Article 99 currently. It's very curious. I don't quite understand what the logic was behind putting that particular clause in the Constitution. So it's proposed to remove that clause so that anybody who qualifies to go to the National Assembly can vie. Because that was a limitation that I think was also without basis. And it must be because of the way we wrote our Constitution at that time. We all sat in different rooms in sector interests, and each of us brought our interest and patched it together to compare Constitution. Then we have a proposal to introduce a new article that establishes the office of the leader of official opposition. And I think GS discussed this very, very clearly as to why we need a leader of official opposition. And the need to embrace the immediate runner-up. He explained the percentages. If somebody has lost by a 2% margin and then is marginalized for the next 5 years, this gives a feeling of being excluded. The 40% people who voted for him feel left out of processes and governance, and probably that's why you see us throwing stones very effectively in some parts of this country at every election. So it's proposed to have the leader of official opposition, who shall be the person with the second highest number of votes in the presidential election. The person who gets the second highest number of votes in the presidential election and also achieves at least 25% of the seats in the National Assembly. So it's not only being number 2, lakini pia hawe na 25% of the seats in the Assembly. If he can't get it directly from his party, he can form a coalition so that then they can sit as the leader of official opposition. And it's an official position. If you look at the president's proposed in the Assembly, it will be the Speaker, then the Prime Minister, then the leader of official opposition. So it's a very powerful position that you're giving the runner-up in a presidential election. And I think this would really address the issue of inclusivity, the issue of elections that divide us. It might just address some of those issues, because then people will not feel totally excluded from the whole. So yeah, that is one of it. So it's going to resolve some of those issues for us going forward. Then we have Article 108 that deals with party leaders. We all know that right now we have the leader of minority and the leader of majority in the House. These positions will be wiped away if these amendments pass. It will be replaced by the Prime Minister, who shall lead the proceedings of the ruling party, and then also be the official leader of the opposition, which will lead the opposition party itself. So we'll no longer have a leader of minority or a leader of majority in the National Assembly. We will, however, have a leader of minority and a leader of majority in Senate. Now, you all know we have them in Senate today, but it's not a constitutional provision, it's a statutory provision. The Constitution does not provide for a leader of minority or a leader of majority in Senate as currently constituted. Those provisions are found in a statute. So right now it's being elevated to a constitutional provision, and going forward those will be constitutional provisions for the Senate. And then there are proposals to amend Article 113, which deals with mediation committees. Now when the Senate and National Assembly have a bill, either Senate or National Assembly drafts a law, and it is passed by one house and it's supposed to be passed by the other house, but then there's a contest, the other house says, no, we don't quite like this provision. The law provides that they form a mediation committee that looks at that bill, decides on it, and then agrees. So we have what they call a mediation committee. Now currently bills from the mediation committee should be submitted to the president after agreement by the National Assembly. This has caused a lot of problems for Senate, because sometimes the National Assembly sits on those bills. In fact, right now the National Assembly is supposed to file within 7 days, and sometimes they do not. So it's proposed now that the bill be sent to the president by the house that originated the bill. That frees Senate to be able to do their work without being held ransom by the National Assembly. Secondly, the time for forwarding it has been increased from 7 days to 14 days to give sufficient time for sending it. Then there is the provision in Article 115, which talks about delegations in Senate. Now, what's a delegation in Senate? Because Senate as currently constituted has 47 elected senators, and then we have about 20 nominated senators. Now you find that there are some counties that have more than one senator in the House. Say that the nominated person is from Kisumu, and Kisumu has a senator as well already. So Kisumu will be having 2 senators. If a matter was to be voted on that touches on the counties, Kisumu would have an unfair advantage if each senator were currently to vote. So the Constitution now provides for what it calls delegation. So delegation means we have every county represented by just one person. And it has what they call the leader of delegation, which in most cases is the senator. But if the senator is not in the House on the same date, he can delegate to someone else to take the vote on his behalf. So that is what the delegation in the Senate currently is. There is leader of delegation, and on county issues, they do not all vote. Only one vote per county is taken. But because now the proposal is to have 94 senators, each county having 2 senators, then the issue of delegations is done away with, because each county will have an equal vote at every time. So the issue of delegations is being deleted from the entire document, and voting in Senate will be on equality. Everybody will have the right to vote. You may have had the Senate, women in Senate, the nominated senators say they are looked down upon because they cannot vote, but now they will have equal right to vote going forward. Then we have the proposed amendment to Article 130, which deals with the National Executive. The National Executive as currently constituted, they consist of the President, the Deputy President, Cabinet Ministers, and Cabinet Ministers. It is proposed to add to this team a Prime Minister and Deputy Prime Ministers. So the proposed office of Prime Minister and the proposed office of Deputy Prime Minister shall form part of the National Executive in Kenya. And as this was explained earlier, this was a proposal of NCCK to the Building Bridges Initiative. It was a proposal of NCCK because it was addressing the issue of the winner takes it all. It was allowing an opportunity to embrace and share opportunities with as many other people as we have, rather than the 2 who were riding a sports car that is red in color. So yes, that is what the proposal is. They shall be members of the executive. And then it says that the authority of the president can be exercised by the president, the deputy president, the prime minister, and the deputy prime ministers. So again, you can see how powerful a position this prime minister and deputy prime minister shall occupy. They're not only members of the executive, they can also exercise executive authority in the country. Then it is also proposed to rename cabinet secretaries to become cabinet ministers. I think this is just a name thing. They don't like sounding like secretaries. They want to feel the full power, powerful. So they want to feel the full power of their name and office. So that says no cater, nothing much. When it comes to the functions of the president, we all know that the president gives an annual State of the Nation address every year to Kenyans. It is proposed to include in his annual State of Address progress in attaining the Article 43 rights. These are the economic and social rights. He must, in every State of the Nation, going forward, should these amendments pass, address us on the progress his government is making in attaining Article 43 rights. Now, what are these Article 43 rights? Housing, health, water, security, adequate food. So those kind of things will have to be addressed by the president at every state of the nation reports to Kenyans. This is very, very powerful provision because it means the government cannot forget to address this issue. It must make efforts to report to us every year that last year there were so many homeless, we have reduced it to so many. That we now have running water in so many places. So these are things we are hoping will then improve because Kenyans will then be asking questions after every state of the nation address. What happened to health? Why didn't you tell us? So these are things that are very, very powerful proposals because once they are constitutional, we can even question the president in court and ask why he is not doing enough to address these issues. And these are the issues that affect Mahasa, These are the issues issues that actually make the person down here wananchi Kuchini. They suffer these little things, and it's important that they address. And it's not just the wananchi Kuchini. We all suffer bad hospitals. We all know how bad it is to have bad hospitals. Some of us build big houses in beautiful places. Hakuna maji. You start putting water in tanks. To be able to, you can't flush your toilet. Medina nyumba poa sana with toilets from Dubai and God knows where, and you don't have water. So these are issues that affect us as human beings. It's our dignity that is addressed when you can have suitable housing, water, health facilities, the right to trade. And I think Article 143 is one very powerful clause in the Constitution. And I'm glad to see that the proposals being attention to this. Then there are proposed amendments to Article 132, 134, 152, and 153. All these just relate to the name of Cabinet Secretary, changing to Cabinet Minister. As I said earlier, that is non-issue. Then when it comes to presidential elections, the Constitution currently provides that if the presidential running mate were, God forbid, to pass away before an election, then the election would be called off. So it has been proposed in the amendments that even if the running mate passes away, the election will proceed and the candidate will be able to nominate another person as his running mate going forward. So the election will not stop merely because the running mate is not available anymore. So that's also, I think, useful. Because elections are very expensive. If you call them off, it will be very, very costly. And also, the temperament of Kenyans and the emotional trauma Kenyans go through around elections, delaying an election because the running mate died will have much, much more devastating effects for us, consequences, than to continue. So I think that's also a useful proposal. Then when it comes to the election presidential petition, we all know that currently, in 2 weeks, the petition is had and done. Sindio? We see it on TV, all of us. Tumechoka, hebu tusimame.
So you see that thing up there? There's something up there. No, behind you. Just behind you.
I see it.
Okay. Okay, let's do this. Breathe in. Breathe out. Breathe in.
Okay. So when it comes to the presidential election, currently it's 14 days. It's proposed to increase that to 30 just to give the court adequate time to do and conclude that. The office of the Prime Minister is established. The Prime Minister will be a member of the National Assembly. So you have to be elected a member of the National Assembly and then appointed the leader of that party that has won in the Assembly, and then you can be nominated the Prime Minister. The Deputy Prime Ministers will be appointed by the President himself directly. This will therefore now create 5 more positions, expand the executive, and be very, very useful up there. For the cabinet, you know right now we only have cabinet ministers and no deputies. It's proposed to have deputies to assist the cabinet ministers. I think this will take over from what we currently know as the CAS. So that is there as well. And now when it comes to the secretary to cabinet and principal secretaries, currently they are vetted by the National Assembly after being nominated out by the President. It is proposed that they shall no longer be vetting of these people by the National Assembly. The President shall appoint and they shall just take their jobs without being vetted by the National Assembly. I think this is in a way unfortunate because it weakens the oversight role of the Assembly over the processes that the President effects. The Director of Public Prosecutions is elevated to an independent office. and the number of years required for his appointment is proposed to be increased to 10 years, to 20 years from the current 10 years, to 15 years from the current 10 years. When it comes to the Court of Appeal, the President of the Court is currently serving on an unlimited term. It is proposed that they serve just one term of 5 years, and it is the same for the principal judge of the High Court. It is also proposed that all election petitions other than the President's election petition terminate at the Court of Appeal. Beyond the Court of Appeal, there should be no further processes. Currently, we see a case where a lot of these cases are taken to the Supreme Court, and then there's never an ending story to it. So the proposal to amend this constitution says that cases or election petitions relating to anything else will terminate at the Court of Appeal. And then the current constitution does not say how long a deputy chief justice should serve. It provides that a chief justice will serve for 10 years, but it doesn't provide a tenure for the deputy chief justice. So it's proposed to provide that the deputy chief justice will serve for 10 years. Then it is also proposed that a chief justice and a deputy chief justice should have 20 years experience, up from the current 15 years experience that is required. Then there's a proposed introduction of a judiciary ombudsman. The ombudsman is supposed to receive complaints and investigate complaints into the affairs of everyone at the judiciary, from the clerks to the magistrates to the judges. And he sits as an ex-officio member of the Judicial Service Commission, can initiate a petition against any judicial officer, and is an independent office. The contentious bit with this is the fact that the President appoints the ombudsman, and that's where they claim the independence is affected. But that's a dicey issue and something that can be looked into further. And then when it comes to the JSC also, it's proposed that the lawyers who sit on the JSC should not practice before the courts, just to rule out conflict, which is also very possible that can arise. So that's the issue. Those are the issues with the judiciary. When it comes to the county assembly, it is proposed that the governor can appoint members of the CEC from amongst members of the county assembly, but not more than half of them should come from the county assembly. Again, nomination will be based on the overall number of votes won and not the number of seats that a party has attained. In the county assembly, we already have the affirmative action where special seat members are nominated. So it's proposed that that provision expire within 10 years from today. So that's proposed to happen. The governor is encouraged to consider having a running mate of the opposite gender. So it's provoking thought in governance to consider that as an issue. And gender can use that as a ground to gauge who to vote for or not to vote for. When it comes to sharing of revenue, currently revenue is shared based on the last audited accounts. Accounts are audited by the Auditor General's office. Based on the last audited accounts that have been debated and passed by the National Assembly. This has caused delays because the National Assembly is never current on the audited accounts, and therefore the counties have been getting less money. It's therefore proposed that it be based not on the accounts that have been debated by the Assembly, but the last audited accounts that have been submitted to the National Assembly by the Auditor General. This will at least translate into more money for the counties because they'll be using the most recent accounts and not what Parliament is sitting on. Then it's proposed to increase the revenue allocation to counties. I think everyone knows this, from 15 to 35%. I hear people asking, are you 35 watatoa become a 15? You are always good to play. But let's just have it in the law because then you can demand it. It will be a provision. So I think let it be there. Then the counties can have a voice and a reason to ask. So that is fine. We have an equalization fund in the Constitution which provides that countries that were previously marginalized are given a bit of the money to try and elevate them to status of other cities and towns. This was supposed to expire after 20 years from 2010. It is now proposed to extend that period from 20 years to 30 years. So it will expire in 2040 going forward, and not 2030 as was initially intended. Then CDF and the World Development Fund had made constitutional provisions so that now no one will question why counties are getting, constituencies are getting money, or why wards are getting money. When it comes to division of revenue, we've seen always these delays where counties say pesa imechelewa, hatuna pesa mashinani, because Parliament has yet to debate the division and allocation of revenue bills. The proposal here to address that is that where Parliament delays in debating those bills, counties can receive up to 50% of what they expect to be allocated in advance as Parliament continues to debate their bills. This will allow counties to continue their businesses without stalling, even as Parliament does what the law requires it to do. And I think this will also be useful to our counties. When it comes to security, it is provided that the IG shall have powers to discipline, transfer, and promote his officers. Currently, that power sits with the National Police Service Commission and has caused a lot of friction, considering that the National Police Service is a discipline force which is under a certain form of special command. So now when you give that power to an NPSC, which is made up of civilians, the disciplined command is kind of lost or diluted. So the power is now proposed to be invested in the IG, the Inspector General, and it has been taken away from the National Police Service Commission. So that's one thing that has happened there. And then it is proposed that the DCI, the Directorate of Criminal Investigation, becomes a formation within the National Police Service. Right now we have just two formations, the APs and the Kenya Police. Yeah, so it is proposed now to have the Kenya Police, the APs, and the DCI as a third formation. Now what will be the effect of that? We'll have to have a deputy IG for the DCI as well. As you see now, we have just two IGs, we are going to have three IGs. And I think that's just to give recognition to DCI, because it's always been a contestation. Our DCI, what are they within NPSC? It's never really clear. So I think that clears those issues around security. So basically, Chair and General Secretary, those are the main amendments in this document. That I would have liked to bring to the attention of our members this morning. I'm sure we'll have much more time to interrogate this further. Thank you very, very much, and I could answer any questions.
Yeah.
Let me get my book.
Yeah, you must be interpreted. Yeah. Yeah, I think Roselyne has already mentioned key things which were disturbing us most in a very simple way. Plain facts. So if there is any question, okay, 1, 2, 3. Let's start with those three first. Betty. Can someone tell me? Yeah.
Thank you so much, Roselyne. You made it so simple. Until now, I think I can facilitate this. And I can stand as a lawyer. People mistake me as a lawyer. Thank you so much. I don't have a question, but I have a concern. My concern, I have two concerns. Number one, the protection of the Constitution. Because we are seeing the contest. We saw the contest in 2010 Constitution. Again, we are seeing the BBI, the contest and the political temperatures that are coming in. And I think there are personal interests that are being driven by this, and more so they are politically based. So I don't know how this, if we manage to go through and maybe amend the Constitution, how is it protected for the future personal interest of the politician, not to again soon push us into another amendment? I don't know whether it is even in that provision or how we go about it. Second concern, we've been seeing a sick nation. Our healthcare system has not been stable. And with that, the whole country can attest to it. And some time back, there was a provision, I don't know, there was a suggestion that we have the Health Commission. I don't know where it went to and how is it being taken care of. And I think now we have the advantage actually to stabilize the healthcare system. What are we putting in place, or what is there in the Constitution to cushion Kenyans, because Kenyans have died, people have suffered. What are we doing? And I think it is the role of religion to protect and advocate for Wananchi. Thank you.
Thank you so much. The key issue is how to protect the Constitution. So I think Roselyne has to that. Okay. Second question.
Thank you, Madam. I was just listening to hear whether the bill here will address the material office vacuum. That one we have witnessed in Nairobi for years.
Can you repeat yourself, please?
Okay. How can we replace somebody like a governor or a deputy governor? Does it address that?
Okay, number three. Number three was Allocation.
Thank you very much, Roselyne. Certainly you are explaining the professional. You know that you are also a candidate. You are about to be our chairman. Very narrow. You missed it, but maybe next time will be. Now my question is, some people are going to court to stop this. And they were told that they could not stop other, I think council assemblies, whatever the council assemblies are doing, they could just continue, but they have stopped IBC from proceeding operation for down. They have told us that there are some sections, if they are passed by the National Assembly, and if they are not subject to referendum, they will just automatically become law. Will those people have gone to court, will they stop that one also, or these ones will just automatically become law, even if those court people will say no, questions have not been settled?
Okay.
And now that I have the microphone, allow me to ask a question. Roselyne, I was looking on the second schedule of the new 70 constituencies, And I'm wondering what criteria was used to determine which constituencies needed to be divided.
Okay. Which criteria did they consult with us? The last one? Okay, you are the last one. You are the focus? Yes. Scripture. Oh, yeah.
Thank you, Madam Roselyne, for the good presentation. Look, I'm just raising a concern from the chair, honorable chair, through the religious voice, that we are really lacking in our ethics and morals as a country. And the voice of the church is not being heard so strongly. And we are talking about the national ethos that has been lacking. And there are no mechanisms, you can't see the mechanism through which this will be achieved. My suggestion is the church needs to always become more pushy so that they also involve in these processes and maybe recommend the ways we can achieve that. And lastly, my other concern, Roselyne is a lawyer. How comes when it comes to executive power, they are increasing it? When it comes to commissions, they are being lean and saving costs. But when it comes to the executive, they're ballooning it. So that should be a concern for us. Thank you very much. Otherwise, I think many of the things are going to pass it.
Yeah. Okay, I think give Roselyne now the opportunity to respond. Give that microphone.
Yes, thank you, Chair. Yes, Betty, you talk about protection of the Constitution. How do we ensure our Constitution is not just made a fun of and abused by the political class? Now, first of all, we probably need to understand that constitutions are creatures of politics. It's a creation of politics and the political class to large extent, and will always be so. It's something that they will always use to their advantage when they have the power to do so. But the power lies in us as a people, and that's why we have the clause of Article 255 that secures certain parts of the Constitution from meddling unless the people who donated their power to the political class say so in a referendum. So Article 255 is the gatekeeping clause in terms of how citizens protect the Constitution, and our power lies in a referendum. And I guess that's to a large extent why we're carrying out civic education today, so that you understand what you're going to do in a referendum. You understand what they are proposing. This is your document, and when it comes to you in a referendum, you need to make an informed choice. So our gatekeeping clause is actually Article 255. And as a people, through advocacy and a lot of things that we can do, we can always protect ourselves and protect Kenya from the political class as well. The religious people have a very loud voice in this country and a very respected voice. And when you speak, you're listened to. And a lot of the proposals in this document, I must say, came from our National Dialogue Conference. And therefore, the church has a strong voice as well. So sometimes you don't even have to wait for Article 255. You can use other means of diplomacy to get yourselves heard and to protect Kenyans and protect the Constitution. So I think we're doing quite well in that regard as a religious body, and even interfaith bodies, we do quite well in that. The other issue you raise of a sick nation, very true, very real. Health issues are of great concern to us today, especially in view of the pandemic. We all know the vaccine has arrived today, but there's no clarity on how and who to get it, as opposed to other countries where there was an online platform and you could have booked by now and you would have known your first, second occurrence. And those are some of the opacities that occur in this country, some of the corruption that we see in this country, and some of the things we need to speak about. But hopefully Article 43 being addressed going forward will be able to address these issues, because Article 43 protects the right to health and the right to all the economic and social issues that we have with us. So hopefully addressing Article 43 as a main issue. It's not just the president required to address them, even county governments in their budgets must justify what they have done towards progressive attainment of Article 43 rights. So going forward, even revenue allocation to counties will be based on their ability to spend on Article 43 issues. National revenue, treasury resources to government entities as well will be based on how they have achieved Article 43 rights. So I think we are moving to a better space if this happens. So that should happen. The vacuum in the governor's office has not been expressly addressed in these amendments so far, but what it says especially is around the fact that the CECs do not vacate office merely because the office of governor has been vacated. So in terms of the ministerial structure, that should be in place. In terms of the vacuum in the office of deputy governor, I think it was unprecedented. That statute, the Election Act actually provides for it. And if you look at the case of Nairobi, the process had been initiated but was stopped by the court. It was injuncted by the courts. So the process was in place, an injunction was held. You could not appoint someone else when a matter is sub judice, when a matter is in court. So I think the gaps are addressed by statute, and we don't quite clearly need a constitutional provision around it right now. There's no real lacuna in the law in that regard. Court cases. The court cases will not stop the process because the injunction is very specific in terms of what it has injuncted. But should any provision come into light that someone thinks is unconstitutional or otherwise, they can still litigate it in court and litigate the whole process in court. So it's not lost. It can still be recovered should something happen. Criteria for new constituencies. They are not new constituencies, yes. They have just said we need to have new constituencies in these counties. So what they're saying is this is where the constituencies should lie, but the boundaries will be defined by IEBC, and they need to do that within 6 months of the passing of this. So the criteria was population, and that criteria is also found in the Constitution. So that the country with the highest population should not exceed 40% of the other counties. So there's a mathematical arrangement to it, which now IBC will go further into in terms of coming up with carving out the actual constituencies. But in terms of their location, they just use the last census, they use the highest population density, but they have also protected counties with very low population which were under risk of being taken away because of having very, very low population. So they have also protected those constituencies in this creation of new constituencies. But the main criteria is population density. Our ethics and morals and national ethos, a good point you raised there. We need to work on our national ethos as a people. But I think if you read the steering committee report, the BBI steering committee report, a lot is done to try and address these issues. And if you look at Article 18A, the responsibilities of a citizen, they are also trying to import into us a value system as a people, so that we do not just engage in waste, we do not just engage in crying for our rights, we also give back responsibly. So those may just create our national ethos. And then why they're increasing executive power and decreasing the size of commission, the sizes of the executive, and increasing the size of commissions. Again, I'll just tell you, this is a political process to large extent, and human beings are political by nature. We are governed by politics before we have societies. So to large extent, politics will always rule the day, but again, I will echo what we said earlier, that there was a need for inclusivity. And that again came from the national dialogue meetings that we had that were organized by IDRG. And we looked at the issues. This proposal is actually our proposal as a church. It's actually our proposal as a church to BBI, that we need to have a 5-man executive so that there's some sort of inclusivity at the top. So let us not discount it. We had good reason for it. We talked about it at length at several meetings, and it is all based on the need for inclusivity. And I think it is well intended, and it's a mark of respect for the church when we see our proposals see the light of day. Thank you very much, Chair.
Thank you. I think that's well. Why don't we clap for Roselyne? Thank you so much. In our church, what we normally do, like protecting, if we know that there is something people might manipulate a certain process, then we put a moratorium. Like if you say this constitution, once it is passed, the way it's likely to be passed, then we say any constitutional review should be commenced after maybe even 20 years, or after every 20 years, or something like that. But you know, constitution addresses issues of our time, and it's something that you cannot say is static. Yeah, it's dynamic. So the dynamic nature of our thinking, of our engagements, may lead us to the drawing board and again to look at the same thing. So I think let's just leave it at that. So I just want to say thank you so much for sharing with us and for giving. Now I just want to recognize Bishop Boyle came late when we had already started. Why don't you just wave to us, please? It would be sinful not to give you time.
You are all blessed. Please raise and sit. God bless you. Thank you, yes, welcome.
Thank you. Edwin Ogolotino, General Secretary, CCA, I understand you have also come late. Just wave to us. Thank you. Any other person who came late when you had...
Myself.
Oh, Eliud, this is my vice chair who comes late.
But I'm here.
Everybody is here.
Thank you.
Thank you. Any other person? Oh, Bishop. Is still strong. Still very strong. Yeah, so I want to say thank you so much. Now, I think we'll break, and before we break, just one more reminder for the countries that have not submitted the names. May I repeat, Kisumu had submitted, Nyamira,